Welcome, guys. Welcome to my life. So today I am making chicken and salad for dinner. Guys, I lost my voice 2 days ago, so bear with me. I lost my voice. I had flu. But I'm feeling better, but my voice is gone. I sound a little bit like a rogue. But yeah, I'm feeling better, just my voice is still not the same yet. I've been defrosing this chicken for 3 hours now. And it's still like this. I've been defrosing it for 3 hours. So the fastest way to defroze your meat or your chicken is to add salt in a warm water and put your frozen protein inside it. It will be frozen in a minute. That's the easiest way to defroze for the fastest. I'm washing my chicken over here. In case you're just joining my life, I'm washing the chicken over here. And
Yeah, me too. Okay. One second. Please be quiet. So we're on this section here.
Thank you, Latin plants.
I'm just wondering, do you want me to just because I know some of those cases were a bit long-winded. Do you want me to just go over the principles that were the key principles in those cases? Or shall we just move forward onto this section? I'd like to have it revised, but it just really depends on if we have time. If we don't have time, then we can. Okay, I think we'll move forward, but if we have time at the end, then I might go over them again. Yeah, no problem. Thank you. Yeah? Okay. So this next section is it's about guarantees, and again, some of the cases are a bit long-winded. So if you can just try your best, basically. Just before we start, there's a difference between, you need to remember this, there's a difference between an indemnity and a guarantee. You might have heard the word guarantee before in language, but you may not have come across the legal principle of indemnity. I'll just explain what they each are. An indemnity is a promise to cover another person's loss or a company's loss regardless of the default, the breach, basically. And a guarantee is a promise to pay only if the original debtor, the debtor is a person or company that owes the money, fails to pay. Do you want me to repeat that? Yes, please. So an indemnity, that's a promise to cover another's loss regardless of the breach or default of payment. And a guarantee is a promise to pay only if the original debtor fails to pay. I don't know if I'm recording actually, should I just check? No, you're not recording. 1 second. Start recording. Okay. So we're gonna, these next set of cases are around whether whether the promise was a guarantee or an indemnity. And there's different requirements for a guarantee. And so when you have a dispute, people try and get out of it by sort of saying, well, actually, it's not that promise was enforceable because it didn't comply with this or it didn't comply with that requirement. And then they'll say, oh no, it was a guarantee, or no, it was an indemnity. So these are what we sort of cases that we're going to be looking at. So people are just trying to escape their liabilities, basically. So there is now only one type of contract that needs to be evidence in writing, and this is a contract of guarantee, and it's under Section 4, and it's the sole survivor of the Statute of Frauds in 1677. So that's how old which this Act, Statute of Fraud 1677 applied, 6 other such contracts, but they're no
Rebecca, use my hand to
enforced. The only one now that's relevant is the contract of guarantee under Section 4. And look how old the Act is, 1677. So guarantee occurs when one person is unconnected with the contract, so they're not a party to the contract directly, promises to pay one of the parties in the event of the other party defaulting on its obligations. Do we understand what that is then?
I think so.
So you have two parties to a contract. Say, for example, you, Donna, and Anna. You're the two parties of the contract, yeah? And Gina or myself can be the guarantor. So, for example, if I give a guarantee, say, for example, to Anna, if Anna doesn't pay what she's supposed to pay under the contract, and I'm not a party to the contract because the contract is between you, Donna, and Anna. If Anna defaults on the contract, her obligations, then I promise to pay what she should have paid. I'm the guarantor, I'm guaranteeing, giving a guarantee. Does that make sense?
Yeah, that makes sense.
Yeah. So the essential issue here is to understand the distinction between an indemnity and a guarantee. And it's only a guarantee that must be evidenced under Section 4 of the Statute of Fraud 1677. So that means for a guarantee to be valid and enforceable, for you, Donna, to force me as a guarantor to pay because Anna has defaulted, you have to show that that guarantee was evidenced in writing. Otherwise, you can't force me as a guarantor to pay if it doesn't comply with Section 4. So you will appreciate that much of the case law has been in effect about making this distinction. So if I say, actually, Donna, I know you're wrong, it wasn't evidenced in writing now, and it's only therefore it's only an indemnity. For example, a guarantee. If I argue that actually when we can't prove that it's been evidenced in writing, then you can't force me to cover Anna's losses. Anna's default. So you won't be able to enforce that against me if there's no evidence in writing. So you appreciate that much of the case law has been in effect about making this distinction. It can be an advantage to show that the alleged contract is one of indemnity rather than a guarantee, because in such a case, a contract of indemnity, all evidence can be brought as a proof of existence. So you would, Donna, you would argue that actually that promise that I made was never a guarantee, it was an indemnity, and therefore you can enforce it, because an indemnity doesn't have to be evidenced in writing. Because you want to recover your loss, right? Anna should have paid you something under the contract. She can't pay for whatever reason, she's defaulted. I've given Anna a guarantee. Anna's guarantor, that if she doesn't pay, I will pay, or she should have paid. But if I say it's a guarantee, I'm going to say, well, it's not evidence in writing.
Right,
you
I need
can't
to bring you
force
guys
me to pay
closer
because it's,
to what I'm
it's not in
missing.
writing. It's not been evidenced. You're going to argue that it's not a guarantee that had that promise. It was an indemnity, and therefore it didn't need to be in writing. Do we follow what's happening here?
Yeah.
Yeah. So an example of this is in the case of Mount Stephen versus Lakeman, a House of Lords decision. The chairman of Brixham Board of Health stated to a contractor engaged to do the work in the council, go on to Mount Stephen and do the work and I will see you paid. So that's the promise that's been made. The Board of Health later disclaimed responsibility for the agreement, and the contractor claimed the money from the chairman himself. So remember, the chairman said, this is the chairman of the board, go to Mount Stephen and do the work and I will see you paid. So the board had later disclaimed responsibility for the agreement, and the contractor tried to claim the money that was owed to him from the chairman directly. The chairman tried to argue that he had only acted as a guarantor, and that as the agreement had not been evidenced in writing, no legally binding contract existed. So he makes this promise, and the chairman then says, actually, it was a guarantee. And because I was given a guarantee under Section 4, it must be evidenced in writing. It was not evidenced in writing. Therefore, you can't enforce that promise against me. But the House of Lords held that this arrangement was an indemnity rather than a contract of guarantee. The Lordship decided by the words he had spoken, the chairman had accepted primary liability. And as noted earlier, contracts of indemnity do not have to be evidenced in writing. So the contractor was able to bring oral evidence before the court to prove that the agreement existed. The contractor said, actually, no, it wasn't a guarantee. It didn't need to be in writing. It was an indemnity. And because it's an indemnity, it doesn't have to be in writing. And he's bringing oral evidence to court to say, this is what this person said. And the House of Lords agreed that it was an indemnity. And therefore, it could be enforced against the chairman directly. Does that make sense?
Yes, it does make sense.
Yeah.
Sorry, did you say anything on that? I didn't catch what you said.
Yeah.
Yeah. So in contrast, only a guarantee was found in this case. Action Strength Limited versus Trading as Vital Resources versus International Glass Engineering 2002, which involved three parties in a building contract. So you have the main contractor, B, a subcontractor who is hired by the main contractor. Usually in building contracts, you have the main contractor, then they hire lots of subcontractors to do various parts of the building work. And the person engaging them is the person who engaged the main contractor, C. A had threatened to pull his labour off site because B, the subcontractor of the main contractor, had regularly been late in paying for the work. So C is the person who's engaging the other two parties. He has his main contractor to do the main building work. Main contractor does a subcontract to another building company to do certain parts of the building work. And this is quite normal in development, property development. Then B, the subcontractor, which is party A, says, I don't want to carry on with this because I've been paid very late each time by the main contractor. A then claimed that C, the person who originally, hired the main contractor, so the subcontractor says that C had promised that if he kept the men there where they were working, that C would ensure that A was paid for the work, and if necessary, by deducting the money that he was going to pay A from the money that was due to B. So do we follow what's happening here? So let me. So pay Anna, you're the subcontractor, you're the main contractor, Anna. And Anna, you hire Donna as your subcontractor to do a part of the building work. Do we follow?
Yes.
Yeah.
Okay. Now, now Donna is a subcontractor. She says, actually, you know, you, Anna, have not been paying me on time. You've regularly been paying me late. And I'm taking my labourers off the site. I'm not going to carry on with the project. I'm not going to carry on with the bill. This is Donna saying this because, Anna, you've not been paying her regularly. Then Georgina says to Donna,
Please like my live. If you come in,
carry on working,
try commenting, try liking the live.
and that Georgina would pay Donna.
If you come into my live, please try liking it, try commenting
Georgina owed
to
you, Anna.
so the algorithm, so the YouTube algorithm can actually suggest my YouTube lives to other users. Okay, guys. Thank you in advance.
So,
Michael Vincent, nice kitchen. Thank you, Michael.
so basically,
Hi.
he's saying that Georgina had made this promise to Donna, saying,
What am I cooking today? I am making fried chicken with salad for dinner.
Against the money that I paid you. So when
say hi if you come in. Okay, guys.
sued Georgina because she failed to keep that promise, the Court of Appeal decided that if your story was true, if their story was true, and this would merely be a guarantee, remember, has to be evidence in writing on Georgina's part, and there is evidence of such agreement, and therefore the guarantee failed. So the court saying that actually, when Georgina had made this promise to Donna, you keep your men there, you carry on work, get them carrying on working, completing the build. I'll pay you, I'll deduct the money that I owe to Anna against the money I paid you. They said, well, actually, that was a guarantee that had been given by Georgina. And because there's not been evidence in writing, you couldn't, Donna, force that against Georgina. So that's what's happening there. So in this case, they said it was when he said, go to Madam and do the work and I will see you paid. They said, well, that was an indemnity. And in this case, they're saying it was a guarantee. So the issue of evidence in writing has also risen in two recent cases. The first is, in this case, GMAT Commercial Credit Development Limited versus Sandu, 2006. Formally valid agreement had been executed under seal. Questions then arose as to whether the guarantee was valid because it had been drafted in such a way as to be meaningless. The claimant sought to avoid these difficulties by seeking rectification. The guarantor, the person who's given the guarantee, argued that such oral evidence to allow rectification of the document would be contrary to statutory frauds. So in this case, remember that we've got this guarantee, and the way the guarantee is being written didn't quite make sense. So they're saying we need to rectify this. I need a rectification. And obviously, when someone is trying to enforce the guarantee, the other side doesn't want to pay, the guarantor doesn't want to pay, they're always going to find a way to get around it. And they're saying, well, if it's going to be a rectification, argue that such oral evidence to allow rectification of that was contrary because it should have been evidence in writing. So that's the issue that arose in that case. There is no English authority on this point, but there was a Privy Council decision, in this case, United States of America versus Motor Trucks Limited, 1924, in which it was held that the oral evidence to rectify a contract was permissible. So the judge and GMAC argued that the same principle should apply here, therefore oral evidence was allowed to rectify a guarantee. And this view is also supported in this by the New Zealand decision in Whiting Driver Plumbing and Heating Limited 1992. So in this case, we did have a valid written guarantee. Because of the way it was written, it was slightly meaningless. It needed rectification. I needed some changing to it. They were trying to introduce oral evidence as if to allow the rectification of the documents. And they said, well, if you rectify that document by oral evidence, then because the oral part of the rectification of evidence is not evidenced in writing, i.e. should all be in writing, they're arguing that it's not it doesn't comply with section 4 of the statute of frauds. But then the court relied on this decision of the Privy Council and said that oral evidence to rectify a contract was permissible. And the judge and HEMA argued that the same principle applied in that case, and that oral evidence was allowed to rectify a guarantee. The guarantee itself was written, but the rectification was oral evidence, and that was allowed. So secondly, in this case, J. Pereira Fernandez, South Africa versus Meta, the court had to consider the requirements of writing in relation to an email. The facts of the case were that Mr. Meta was a director of the company, which was a debtor of the claimant. Do we know what a debtor is? That's right. So it's either a person or a company that owes money. So Mr. Meta was a director of the company, which was a debtor of the claimant. So the company owed money to the claimants. The claimant, this J. Pereira Fernandez, SA, was proposing to wind the debtor company up. Does anybody know what winding a company up means?
It's closing it, isn't it?
That's right. It's closing the company to sell its assets to pay off any debts that the company owes. So the claimant was proposing to wind the company up, i.e. close the company, and then sell its assets to pay off the debts. So they're trying to wind up the debtor company. An employee of the debtor company, allegedly on behalf of Mr. Meta rather, an employee of the debtor company allegedly on behalf of Mr. Meta sent an email offering a personal guarantee of £25,000 in return for a week's delay in presentation of the winding up petition. So they're given a guarantee of £25,000 if just, delay it by a week, don't wind up the company, don't close the company down. And there's also, so this is an email that was sent on behalf of Mr. Meta. It was also agreed that this guarantee had been accepted orally by a clerk employed by the claimant's lawyer. So they sent this email to J. Pereira's lawyers, and it was accepted orally. The court had to decide two issues under the statute. Firstly, is a written offer in an email orally accepted by the claimant's lawyer a written agreement under the statute? It's not the first issue. What is the significance of the email? So it's a written offer in an email and it's orally accepted by the claimant's lawyer. So what is the significance evidence of that under the statute. The statute being the statute of force, it was 1677. Then the court had a written agreement on the statute. The court had no difficulty in accepting that this email would suffice as a note or memorandum of the agreement. Secondly, a question arose as to whether or not the memorandum had been signed. Now, when it comes to electronic signatures, you have to go and look at Section 7 of the Electronic Communications Act 2000. This requires an electronic signature to be incorporated into or logically associated with a particular electronic communication. Of course, in an email, did not appear in either the body of the email or at the end of the email. This was not enough to constitute a signature. So, the email itself, whilst it counted as written evidence of the agreement, the signature was not accepted because his name did not appear in either the body of the email or at the end of the email. Remember, he was an employee of the, where is, where's it gone? Yeah, employee of the data company, allegedly on behalf of Mr. Mehta sent an email. It didn't come from Mr. Mehta himself. It come from his employee on his behalf. So the significance of this is that this case shows that an email can count as a written contract, even if the other side says yes, the email will make it legally binding. But the issue about the signature is that you have to look at Section 7 of this Act, and the court decided that if his name didn't appear in either the body of the email or at the end of the email, this didn't constitute a signature. Preemption rights to buy shares, and the defendant promised to buy the shares if the buyer failed. The defendant had more luck with his second argument that his promise was a guarantee and therefore not binding as not in writing as required by the Section 4 Statute of Frauds. That's why he argued that he's saying that the promise that he had made was a guarantee because it wasn't in writing as required by Section 4 of the Statute of Frauds Act. It's not binding. The claimant argued that the promise was an indemnity. Obviously, he's going to say it's indemnity because it's not in writing. He wants to force that promise and force it. The claimant argued that the promise was indemnity and therefore did not need to be in writing. And Lord Justice Smith said, looking at the matter in the round, it appears to me that the respondent did in fact promise to satisfy liability of Page if Page fails to pay all the balance shares after they had exercised their options. Remember, the defendant promised to buy the shares if the buyer failed. So looking at the matter, it appears to me that the respondent did in fact promise to satisfy the liability of Page if Page failed to pay for the balance shares after they had exercised their options. Now it looks like a guarantee. There will be no liability on the respondent unless Page failed to pay under his agreements with the appellants. The respondent had no potential liability and no potential benefit under the share option agreements, and the liability was specified. defendant, the guarantors of the second and third defendants. Both the claimant and the defendant companies were incorporated, i.e. set up in the British Virgin Islands. The money was drawn down by the first defendant in April and June 2003 and paid into a Swiss bank account. So the money is lent, and the money is then drawn down into the bank account by the first defendant in April and June 2003. Now, in September 2003, a sequestration order was made in respect of the account by the Swiss public prosecutor, apparently because of suspicions of money laundering by the claimant. The money was released in October 2003, but the balance was held until 2007. So they're requesting the money, and because there's some very suspicion of money laundering, $5 million has been released, but the balance still held in the account for 2007. The capital was repaid, but there's a dispute over the payment of the interest, because the claimant lent $15 million to the loan, so there's a debt has been paid, but there's a dispute of the payment of interest. And the claimant sought to enforce the guarantee. So the guarantee was given by the second and third defendants that if this money doesn't pay the loan back with the interest, obviously, then they would guarantee, they provided a guarantee, so they were in response, they were liable then as guarantors. And the guarantors argued that the guarantee was not enforceable because non-disclosure information about Boris of the moving spirit in the claimant. Do we know what this moving spirit is? Have you heard of this?
No?
No.
So, in legal terms, the moving spirit behind a company or action is the person who's really in charge of the driving things forward, even though they're not officially listed as the boss of the company. So they're the person who is controlling everything, and really the person who's making the decision, basically the boss of the company, even though their name is not on the paperwork, someone else's name is they're the real boss. So they argue that the guarantee given by the second and third defendant to North Shore Ventures Limited was not enforceable because they said there was no disclosure of information about Boris Berezovsky. He was basically the person who was making the decisions, controlling things, and his name was not on the paperwork.
Are you okay?
There should have been some disclosure about him, and there was nothing mentioned. And it was accepted, so that's the disclosure that you provide, that you should have provided information about him.
You don't feel
You
well.
failed to provide that information.
Right.
Failed to disclose information about Boris Berezovsky. And to accept that there was some duty of disclosure, the court of appeal, however, reversing the decision of Judge Newey and rejecting the opinion of O'Donovan and Ford in the Pets Open Contract Guarantee, page 161, that the
Did you
duty
clean
of
yourself?
disclosure is limited to unusual features of the contractual relationship between the creditor and debtor, or between the creditor and other creditors of the debtor. Because of the unusual nature of this particular contract, there was how the duty of disclosure was limited
Jesus, how
because
could
of this strange
where did you go to the back
relationship
garden?
between the
When?
parties. Golden Ocean Group Limited versus Alabama Mining Industries PBT
You
Limited.
scared me for a second. I was like,
Negotiations by email about the charter of a company. So a Singapore company, trustworthy shipping.
Shane, you have
Fully
slippers,
guaranteed by the
you
first
have crocs,
defendant and
you
an
have
Indian
your
company of
sleeping
which the
slippers,
second
but you
defendant,
just
Mr.
came out like
Salgar,
this. And you're going to leave the
Salgar,
crocs. I'm going to put some slippers
sorry, I
on.
got his name wrong, was the majority shareholder. In due course, the defendant
It's
argued
not
that
good
the
to cross
guarantee
over
was
cats
reached in
outfit.
writing within the section 4 of the statute of
It's a
frauds.
taboo to cross over cats. Don't do that again.
Judge Christopher Clark rejected this argument, and the judgment contains a very sort of long, helpful account of the case on adding documents together. The judgment also contains useful discussion of the proper law of guarantee and the proper law of charter party being English law and of questions of jurisdiction. So if you want to read the judgment, you can. It has a lot more information about the law relating to guarantees. The decision has been affirmed by the Court of Appeal in 2012 that the emails could be added together so as to evidence the contract. Furthermore, the name of the broker guy on an email was sufficient signature, provided it came as an authentication that he took responsibility for the contract. There is also a useful discussion of the proper law of guarantee, and the charge party itself was expressly subject to English law. So basically, there's a manual saying that if you want to know more about the law of guarantee and just in relation to charters as well, then read the full judgment of in this case. So it's just sort of signposting you to that. But the principle here is that even if you don't sign the contract, the email shows you agreed on the deal and intend to go ahead, the court can treat it as a real contract. So the court held that the series of emails can form a binding contract if no formal document is signed, if the emails show agreement on all essential terms and intention to be bound is going to be enforceable.
So good.
So exceptions to section 4.
Good.
So section 4 statute of frauds does not apply to the following guarantees. The following might therefore be enforceable in the court of law despite lack of written evidence. So remember, like when you have a statute with a certain section applying to, for example, section 4 saying what their requirements are for a guarantee to be valid. The Act itself also gives you exceptions. No, actually,
It's so good.
Sorry, I'll take that back. This is not an exception in the Act. And when we did the section 2, if I just go back here, the Act itself created these exceptions, these 3 exceptions: leases of 3 years or under, contracts made by public caution, contracts registered by Financial Services Act 1986. So these exceptions are provided in the 1989 Act to section 2. And then you had the court authorities precedents, which also gave you some exceptions to section 2 in these kind of agreements: an option to purchase land, a lockout agreement, and trivial transfers of land.
Do you know where I
Those were the 3
everything?
court authorities which were exceptions to section 2. Now,
the top side is for the chicken.
section 4 relates to guarantees that they have to be evidenced in writing for them to be enforceable.
Top.
And as with
When you're coming out to get me,
whenever you get that, you always find that there's some exceptions, and you find this quite common in contract law. But this is not provided by the Act itself. It's just that there are some exceptions to section 4 in relation to guarantees given in these situations. So the following therefore may be enforceable court of law despite a lack of written evidence. So the following guarantees do not need to be evidence in writing. They can still be enforceable. So
Alfie,
is a special type of sales agent.
you said you wanted
Who sells
tomatoes in
goods
this
on
salad, right?
the principle
Bring tomato
of
from the fridge.
promises pay the principal if the buyer doesn't pay. So therefore, because they're given that guarantee, they get a high
And then
commission for taking
cucumber
on
there
the
as well. Just
risk.
the cucumber as well.
So when you have that,
Check
that
down.
kind of case, then
It's still okay. Just bring one.
that doesn't need to be evidence in writing. So such agents
I'll put that
guarantee
strawberry
retain
after you
an
get
extra
it.
commission. So because they're giving that guarantee that if that buyer doesn't pay, will pay, they
What's
get an
this one
extra
now?
commission because they're taking on an additional risk. So that's why they do it. So such agents guarantee and retain for extra commission that another party will honor his obligations when making the arrangement with the third party, the principal. The agent is therefore promised to pay if the other party fails. These agreements are not covered by statute and follows they have to be part of a wider agency transaction. So because they're acting as in an agency situation, they're acting as agents of the principal. They're not covered by the act. So they're like basically salesmen who guarantee the customer will pay, and if not, they will cover it themselves. Taking on that business, they charge extra commission. So that's not covered by the statute of fraud. Guarantees made by adulterated agents. Guarantees made by a party who already has a proprietary interest in the goods.
Tomatoes are not crunchy.
A proprietary interest is a legal right in the property or land, and it's a real enforceable right over the property, i.e. ownership, leases, mortgages, easements, etc. So guarantee made by a party already has a proprietary interest in the goods. So it's an exception. An example of this occurred in the case of Fitzgerald versus Dressler 1859, where a seller sold linseed oil to another, but retained a lien over the goods until the heat was paid.
Which means we need to start closing the back garden again, yeah? Okay. Because leaving it open for Chase and Penny to explode, inviting all these mouse.
No. It's just like retaining a right over the goods. The buyer then resold the goods to a third party for a higher price. As the third party wanted immediate delivery, he accepted liability for payments to the original owner. He later held guaranteed to pay if the original buyer did not, and was therefore protected by a Section 4 statute of frauds of the agreement was not evidence in writing. The court held that this was more than a mere guarantee. In this case, the second buyer was undertaken to remove the first party's lien over the goods, first party's right over the goods. So guarantee by a party already has a proprietary.
I don't think I should put it. It's so soft.
That's the second exception.
And watery.
And then we've got the last one, which is guarantees made to the debtor. The debtor, remember, is the person or the company that owes money. So a promise or guarantee the debt of another must be made. Sorry, promise to guarantee the debt of another must be made to the creditor to gain the protection of Section 4. So if you make a promise or a guarantee the debt of another person to the creditor, then Section 4, you will be within Section 4. You have to comply with Section 4. But there's no requirement of writing where the guarantee is made to the debtor, as in the case of Eastwood versus Kenyon mentioned in Section 3. And if you remember, that case was a guardian had spent money raising a girl. Her husband later promised to repay the guardian. The promise was made to the debtor, the girl, not the creditor. So it didn't need to be in writing. So it didn't need to
I
be
love you,
writing.
shower.
So that's another exception. If you make if the guarantee is made to the debtor, the person who owes the money, then that's an exception to Section 4. If you make it another person to the creditor, then it does have to comply with Section 4. So we've got those last self-test Ali never cancelled the agreement with Rupert for encyclopedias as she found them very useful. However, she's
Why is
finding
this
it
cucumber
difficult to keep up with
frozen?
the monthly repayments.
Did
She
anyone
had
put the
recently told
cucumber
her
in the
father
freezer?
Arnold about the situation
No?
and that she is struggling to
Maybe
pay.
it's
Frozen?
He told her not to worry
and the fridge
and
for
he
too
will
long.
deal with it.
Sorry?
Maybe it's just in the fridge for
He
too
does
long.
not want to pay the debt
No,
as he's
this could be
saving for a
different
new
from the freezer,
conservatory and he
obviously.
hopes
Cheese,
that
what
Ali
happened?
will be able to continue to make the payments.
Because there was something in
He
the
has
freezer.
heard about the
I mean, the
possibility of
fridge for a long
guaranteeing
time.
a
And
debt
I went to go
potential
pick it
how
up,
to do this
and I
and
was
the
in
implications
frozen.
Frozen, yeah.
So if he was
What's happening?
So what do you guys think? What does he need to what does he need to comply with if it's going to be a guarantee? It's going to guarantee a debt.
Oh, this thing should stay one place now.
So which act governs the
Sorry, I can't
guarantees
hear
of
you.
debts?
Last time I checked, I had 1.6k on that video that I showed you.
What is it now? Or is it still 1.6? Oh, excuse me.
You go right here. Is governed by Section 4 of the Statute of Frauds Act 1677. So what does Section 4 require for a guarantee? That guarantee needs to be evidence in writing. Does that make sense? Yeah. So this act is dealing with guarantees and it's telling you under Section 4 if a guarantee is going to be enforced, it has to be evidence in writing. Remember this topic, certain contracts have to be evidenced in writing. This is about the form of a contract. So for a guarantee to be valid, that contract or guarantee has to be in writing. And it has to comply, and the authority for that is Section 4 of the Statute of Frauds Act 1677.
Is it like?
I'm joking. It's 1.7k.
Careful.
Oh, okay.
Oh no, I almost got
That would be the
slides.
salad.
So,
I just poured a mayonnaise on this.
That's more.
do you know, does it, so
How
you would
much
have to have
mayonnaise do I
a
put in?
guarantee in writing for it to be a valid guarantee. And if the guarantee is given to made to the creditor on behalf of Eileen, who is the debtor,
It's so cold.
then it has to comply with Section 4. But if you make a guarantee to Eileen, the debtor,
I'm going to
then
hold it in
doesn't
for 1
need to
second.
be. But if it's made to the creditor Rupert, it's made on
Oh,
I
you
like
are.
farting.
Oh, was it me?
it has to be for a valid guarantee.
Lana?
It has to be evidence
I
in
know it's
writing. And if that guarantee is given, then Rupert can enforce that guarantee. If he can, if it's done in writing, he will be able to enforce that debt against Arnold because he's a guarantor if Eileen defaults on the
The guy used to
payment.
mix it.
So if
Go ahead.
Arnold doesn't want to, he's saying he hopes Ali will continue to pay. He doesn't want to pay the debts. He's saving money for a new conservatory.
I think
Then
you need to put more
obviously
money in
you'd
it.
advise Arnold that if he does give a written guarantee to the on behalf of Eileen, then he would be liable to pay for that debt if she defaults. Does that make sense?
Yes.
Wait, are you in class?
I am, but
Are you
he's
there?
tired already.
Yeah, makes sense. Alright. So this is the last 5 key points on form. The general rule is that, so this is the general
Careful.
rule, it's just a summary of the end of
If you taste this chicken, I
done
like,
in
oh
this
my
chapter.
god.
The general
Wait, is it
rule
good?
is that contracts
It's
can
so
generally
good.
be
This one's better.
any
Can I
form,
try?
but
It's better
no
than the ones you buy
exceptions
from the shop.
Okay, can I try that to me? I want to have a bite.
Always start with the general rule. Agreements made without consideration have to be made in the form of a deed.
It's so strong
We
to
already
bite. That's the
several
problem. It's
times what
frozen.
a
You
deed
see?
is. Credit
Why
insurance
is it crunchy like
contracts,
this?
bill
I
of
have no
exchange
idea.
arrangements for transferring shares,
They
capital
don't put it in the
compromise have
freezer
to be
and
made
then
in
bring it out
writing.
and put it in the fridge.
So those
No?
particular type of contracts
I
have to
agree
be
back my
in
cooking back.
writing. That's the
Oh.
form of the contract. You cannot have oral contracts for a credit
Why don't
agreement,
you
for
like
insurance
How am I
contract,
2 pits?
bill of
And
exchange
my
arrangements,
grandma.
transfer,
No, because
shares,
my grandma
patents,
too.
they have to all be in writing. In addition, contracts for the sale and disposition of land after this date,
He sounds like you when you scare
September
kids.
1989,
Really?
Yeah.
must be in writing and signed by both parties as set out in the Law of Property Claims Provisions Act 1989.
It's good.
The case law
It's what good.
The mix is it mixed up properly?
being taken about
I'm only seeing you staring on the surface. You're not
and
going to.
refers you to the case of First Post Homes versus Johnson. And then there's only one type of contract now that has to be evidence in writing under Section 4 of the Statute of 4, 1677, and that is a contract of guarantee
That's more
when
mayonnaise.
made with the creditor.
Let me see.
Okay?
I
So
should
that's
have
the key
finished the
point here.
cucumber.
It's a contract of guarantee. It's made with the creditor. It's got to be in writing under Section 4.
I want
The
to get some.
guarantee only accepts secondary
Yeah.
liability as opposed to a contract of
That is a bit
indemnity
more.
which accepts primary liability.
That looks good.
And the latter type of contract
Wait, I
can
already
be
said
made
that.
in any form, and indemnity can be made in any form, as can be seen in Mark's
How many hours still online at this time?
promise was an
Because usually he has his dinner at like 8, like at like 6 o'clock, and it goes to bed at like 7 o'clock. Wake up like right now.
It should be 8 o'clock now. I think.
It's like it's 20 something. 6, 7, 8. Yes.
It's 8.
Yeah.
Late dinner.
No, he has it usually at 6 o'clock.
Who?
Harry.
Harry.
Yeah.
Who's talking about Harry here?
You.
Ooh.
Harry.
Yeah.
Yeah, it's Henry going.
Yeah, just say Harry.
It's not that difficult. It's just that case will can make it sound more complicated than it is.
Yeah.
When we come back in September,
Okay.
I'm
Expect a young
proposed to
baby.
give a lot of
I
questions.
thought you were talking about another
for the
cat.
last 5
And it's like,
topics that we've
I thought you were
Yes, sir.
screaming.
just to
I'm good at
bring
acting.
everything back together and refreshing what we've learned. And I do suggest you just carry on reading
I love the taste of
the
the chicken. Oh,
manual.
Can I taste
I
it?
can't even smell
No, I'm going to throw it away because I'm not making it for humans.
It'll do. And
Wait, aren't you doing it?
you also have to do land lawyer, and that's quite hard. Well, that's another hard topic.
Sure.
And if you just rely on
Don't bite all of them now.
lessons,
I said small, you want to bite everything.
I can't taste anything.
spend some more of your own
What's it
time
for
on
my
this. I've
hand?
said that before as well.
Or
You need to
spices.
spend more time just going over.
Huh?
I can taste spices.
And that's it. And that's,
Okay.
I hope everyone has a lovely holiday.
I have
See you in
spices.
September.
Is that good?
What date is the first class part?
Yeah, it's good.
I can't put the dates somewhere.
And that's good.
Return
The
that.
term starts the
to the
3rd of
fridge.
September.
Okay.
So it'll
I
be the
think I
first
like it
Wednesday
good.
that week.
Huh? Yo.
Oh, I think no,
The
no,
3rd of
No?
September is a Wednesday.
Even if I did, I'll wash my hands.
So Alfie, you never did your
It's
fingers.
3rd week.
No?
Even when the food is very yummy, you don't eat your fingers.
I did.
Let me just, I'll send you an email to confirm. I've written down 3rd week, but I'm not sure if it's the week.
Sorry?
I lost my hands.
If you wash your hands, okay?
I'm not sure, I'll need to double check. Okay. I've got 3rd week down, so it could be 3rd week.
Do you want more salad, Alfie?
Yes.
Yeah?
Yes.
We'll see. Do you want to start earlier than the 3rd week? Would you rather start on the 3rd?
I don't mind. I'm not here on the 3rd, so I'm still away. So, I'm not bothered. I can catch up. So the 3rd week would be better, but
Yeah, I'm just anxious to catch up because we missed one
Cut
week
it
last
out.
week.
Yeah?
So
yeah, I don't mind. I can catch up.
That's a bad week for spending to cut out.
Alright, well then, have a good holiday.
Smells
and
what?
we'll catch
No,
up
I said
soon.
it's not fair. I want to still
Yeah,
go to
that's
school,
cool.
but we have to take
Thank
4
you.
weeks
Bye.
off.
Bye-bye.
You used to go to school tomorrow.
I know, but we have only like 5 days left.
5 days left before the summer holiday. Yay.
No.
Why are you shouting no? Are you not tired of waking up 6 o'clock in the morning? I'm tired.
No, I'm not.
I am.
I like doing work.
Waking up 6 in the morning, cooking pack lunch, traveling 1 point,
Wait,
something
you have to
mine.
travel to Manchester?
Are you okay? No, travel to your school. Your school is very far.
Oh. Wait, by train?
Alfie, leave me alone, please. You know exactly what I'm talking about.
Not really.
Oh, yeah, go then. Leave me alone. Do you not travel to your school?
Oh, I thought you were
Eh? Let me please, I'm not being stupid. So argue with you this evening. Oh, this is showing. I'm tired already. It's more than half an hour cooking this recipe. Okay. Okay, maybe the chicken. Alfie, You know that slippers is your indoor slippers. Why not wear your Crocs when you are going to the back garden? Eh? I corrected you before. You're still doing the same thing. Fine. I prefer you listening better than sorry. Okay? Sorry sounds good, but I'd rather you listen. Oh yeah, you guys come down and eat. Okay, now it's done. I only put a little salad for you in case you don't eat much. Sorry. Thank you, okay. Yeah, thank you. You're welcome. Ayla. Madam Ayla. Here we go.
Thank you.
You're welcome. Ayla, oh. What's she doing? Taking it down. Happy do you need cutlery?
Yeah.
Yeah.
Thank you.
You're welcome. Thank you. You're welcome. Excuse me. You can say thank you 10 times, it's fine. Yeah. Ketchup for what again? The chicken doesn't need ketchup, okay? It's not dry. I didn't use the air fryer today, so it's not dry. Because there is salad attached to it. Who wants more chicken? Oh, all of you are hungry goats. What about me? Yeah? Me. I only have 2 extra, but you guys are 3. I cannot give 2 and not give the number 3. So it's complicated. I have to eat all of it. Only 2 extra. Oh, Chimo. Ike abugomo. This is my fix dinner. Okay guys, thanks for watching. I'll see you guys in my next live. Bye bye. Let me go and eat. I'm exhausted already. Let me go and munch some food. Bye bye.